Yes.
All right, moving on to question 6. Mr. Ferrero, as county prosecutor, how strenuously would you pursue the death penalty in appropriate cases? And what do you consider appropriate cases?
Very strenuous. We will pursue cases of death penalty. Now, this is another issue, sort of like the marijuana issue. You got people that are for it, against it, and you're going to hear arguments back and forth. The death penalty is a very controversial issue. It's an issue that we deal, on the murder cases that qualify for this case, or these type of cases. Not all murder cases are entitled to have the death penalty specification. You always hear the arguments, eye for an eye, or that it's a deterrent. Then you hear the arguments against it, saying it's inhumane and for religious purposes that we shouldn't have it. But as a prosecutor, I took an oath of office to uphold the laws of the state of Ohio, and that currently the death penalty is an option for jurors to consider in capital murder cases. And when we have a case, a murder case, and we present it to the grand jury, if it's an aggravated murder case, there's 10 circumstances in which the state statute says that we can, or that if it qualifies, the grand jurors can indict with a death penalty specification. Now, how we pursue it is we go to court. If the grand jury indicts on that, then we pursue it in court, and it's really up to the jurors then to decide. If they find a person guilty in the first phase, they will then have the option of determining the ultimate penalty, a death penalty. Since I've been prosecutor, I believe we've only had really one person that was sentenced to the death penalty. That was Mr. Mamone, who killed his 2 young children and his mother-in-law, and that was definitely a case that the defendant should have been faced the death penalty.
Mr. Jakmides.
Well, the Stark County Prosecutor's Office has probably indicted 10 or 15 people on death penalty specifications. I believe they've only one time convinced a jury actually to fix the penalty of death. The rest of them have been plea bargained down so that they were not going to get the death penalty, or the jury didn't agree to fix the penalty of death, but rather fix the penalty with life with no parole. So frankly, the prosecutor's office has been very unsuccessful with the death penalty indictments that they've handled. And anybody can look that up. It's a matter of public record. So in my response to Mr. Ferrero's statements about the death penalty, unlike him, I have actually tried these cases. I know both sides of the arguments here, and I know both sides of the law, and I know both sides of how these are presented and argued in court. So I think I would be much better trying to convince a jury in an appropriate case to fix the penalty of death. And that's what they do. They fix the penalty. They don't recommend it. They fix it. And then a judge ultimately has the final decision. They can reverse it or not. And I've had that happen once.
Now, Mr. Jakmides, your opportunity to answer the question. Would you like it repeated?
Yeah.
As county prosecutor, how strenuously would you pursue the death penalty in appropriate cases? And what cases do you consider appropriate?
Well, the law sets what kind of cases are appropriate. There has to be multiple homicides, death of a police officer, commission of another aggravated felony of the first degree. So there's the indictment that says that you committed a homicide, and then there's specifications. There was more than one death caused. There was a police officer killed. It was in the commission of an aggravated felony of the first degree, and the individual was the principal offender. So the jury not only has to make a finding on the homicide, then they have to go to the specifications. Now, most of those cases, it's a foregone conclusion that the person's going to be found guilty of the homicide. And frankly, a lot of the cases, it's a foregone conclusion they're going to be found guilty of some of the specifications. So then you go to the penalty phase, and that's when the arguments are made for and against death, and the defense has an opportunity to present mitigating factors, and the jury is given instructions. But frankly, what happens a lot of times in death penalty cases is you only have to have one juror who, for whatever reason, and they don't have to express that reason, they can say no to the death penalty. So it could be unanimous guilty on the specs, and 11-1 for death, And then the jury must then go to the next lesser offense, which is less sentence, which is life without parole. So one juror, for whatever reason, no reason, and they don't have to express their reason, can prevent the penalty from being fixed at death. And this is, of course, the great difficulty that the prosecutors have in these cases, is you've got to get all 12. Now, I have personally tried death penalty cases. I've won death penalty cases. I've been appointed by judges in Wayne County and Tuscarawas County and Stark County to handle these particular matters. I was certified by the Ohio Supreme Court to be lead trial counsel in death penalty cases. So I know this inside and out, and I would say they're very rare. Thank you.
Mr. Ferrero, your response.
Yeah, first of all, he says that we've been unsuccessful in getting death penalty, but then he says, basically it is very rare. It is, because you know why? You're asking 12 jurors to do the ultimate act of putting someone to death, okay? And like I said, we swear to uphold the law, and if we get the orders to ask for a death penalty, we do so. But it's up to those 12 jurors, and it's a very difficult decision for them to do, and it's something they have to think about. Also on the issue of plea bargaining, where a person might get life without parole, most of those times the victim's family would come to us and say, we don't want this case to go to trial. If that defendant will plead to that, spend the rest of his miserable life in prison, that's fine with us. And we will do that. And I think when it comes to the cost, studies show that putting a person in prison life without parole is cheaper than putting them on death row.